Anti-money laundering, often called AML, is one of the cornerstones of America's financial crime prevention system. Even if your company never sends or receives money internationally, U.S. laws apply. From banks and brokerages to casinos and car dealerships, thousands of U.S. organizations have AML obligations. The rules are built on two main pillars of law: the Bank Secrecy Act of 1970 and the USA Patriot Act of 2001. Both require businesses to keep records, know their customers, and report suspicious or large cash transactions to the Financial Crimes Enforcement Network, or FinCEN. The Bank Secrecy Act defines financial institutions broadly. This category includes banks and credit unions, securities firms like broker-dealers and futures commission merchants, mutual funds, money services businesses, including money transmitters, check cashers, foreign currency dealers, prepaid card providers, and issuers of traveler's checks, casinos and card clubs, insurance companies. Each category has detailed rules in the federal regulations. For example, 31 CFR Part 1020 applies to banks, and 31 CFR Part 1022 applies to MSBs. Money services businesses must also register with FinCEN under Section 1022-380. Failing to do so is itself a violation. Even non-financial companies can have AML duties. For example, if your business receives more than $10,000 in cash in one transaction or in related transactions, you must file IRS Form 8300 within 15 days. You must also give the customer an annual statement of that filing and keep a copy for 5 years. For financial institutions, AML obligations are built around 5 program pillars. Internal controls, written policies and procedures that set standards for monitoring, reporting, and escalation. Designated compliance officer, a qualified BSA AML officer who has authority and resources to enforce the program. Training, ongoing education for employees tailored to their job functions. Independent testing, audits or reviews performed either internally or by third parties to confirm program effectiveness. Customer due diligence, identifying and verifying customers, understanding their business purpose, and identifying beneficial owners for legal entities. FinCEN is updating AML rules to require programs to be explicitly risk-based. This means companies must create a documented risk assessment that considers the government's official AML and counter-terrorist financing priorities, corruption, cybercrime, terrorist financing, fraud, drug trafficking, human trafficking and smuggling, transnational criminal organizations, and proliferation financing. Customer identification is at the heart of AML. Under the Customer Identification Program, or CIP, banks and similar institutions must verify customer identities using reliable documents or data, provide customers notice of these requirements, keep records of the verification process. Beyond CIP, customer due diligence, or CDD, requires institutions to understand the nature and purpose of a customer's relationship and to conduct ongoing monitoring. For legal entity customers, the CDD rule requires collecting and verifying beneficial ownership information. That means identifying the individuals who own or control the business, not just the business name on the account. For non-financial companies, adopting similar risk-based onboarding practices is recommended. Checking identities, screening customers against sanctions lists, and documenting expected transaction activity all reduce fraud and support compliance with Form 8300 and suspicious activity reporting. Reporting is a critical component of AML compliance. Suspicious activity reports, or SARs, must be filed by financial institutions when transactions indicate possible money laundering or other crimes. Deadlines: 30 days from first detection, extendable to 60 if no suspect is identified. Ongoing suspicious activity requires continuing SARs about every 90 days. Supporting documentation must be kept 5 years. Important: it is a crime to disclose to the subject of the report that a SAR has been filed. Currency Transaction Reports, or CTRs, required for cash transactions over $10,000 in a single business day. Aggregation applies. Multiple smaller transactions must be combined. Must be filed within 15 days and kept on record for 5 years. Form 8300 for non-financials. Required whenever your business receives over $10,000 in cash in a single or related set of transactions. Must be filed within 15 days and retained for 5 years. An annual customer statement is also required. Other record-keeping obligations include the travel rule. For funds transfers over $3,000, information such as the sender's and recipient's names and addresses must accompany the transfer. Section 314A. FinCEN may circulate names or entities of interest to law enforcement. Financial institutions must search their records and respond by the required deadline. Section 314B. Institutions may voluntarily share information with one another about suspected money laundering or terrorist activity after filing notice with FinCEN. These communications are legally protected. AML programs must also integrate Office of Foreign Assets Control, or OFAC screening. This means checking customers and transactions against OFAC sanctions lists, blocking or rejecting prohibited transactions, escalating and reporting when matches are found. OFAC's published compliance framework sets the standard examiners use in enforcement. The Corporate Transparency Act, or CTA, requires many U.S. businesses to report their beneficial owners directly to FinCEN. As of 2025, the rules are evolving due to litigation and rulemaking. The scope, timing, and treatment of domestic versus foreign entities have changed. Businesses must consult FinCEN's latest guidance and Federal Register notices before finalizing policies. Common warning signs of money laundering include structuring transactions just under the $10,000 reporting threshold, customers who refuse to provide identity information or who give inconsistent source of funds explanations, rapid or unexplained movement of funds, including through money mules, transactions involving sanctioned countries, entities, or attempts to evade detection. The consequences of ignoring AML rules are serious. Civil and criminal penalties include multi-million-dollar fines, criminal charges against individuals, and reputational damage. Failures in OFAC compliance can bring additional enforcement actions separate from BSA violations. Here's a simplified checklist for U.S.-only organizations. Determine if you are a financial institution under BSA rules. Register if you're an MSB. Build a risk-based AML program with the 5 pillars. File SARs, CTRs, or Form 8300 as required. Keep all records for at least 5 years. Screen customers and payments against OFAC lists. Train staff at least annually and test the program independently. Designate and empower a qualified BSA AML officer. Whether you are a bank, a casino, a money services business, or even a retail company that occasionally handles large cash transactions, the law applies. By building a risk-based compliance program, training your team, monitoring for red flags, and filing required reports, you protect your organization, and you play a vital role in defending the U.S. financial system against money laundering and related crimes.